Alrighty. While people continue to trickle in, we'll go ahead and get started. Good morning or afternoon, depending on your location, and thank you so much for joining the 9th installment of our export compliance webinar series. As you are all very familiar, it's World Trade Month, and during which the U.S. Commercial Service takes this opportunity to host a number of programs designed to advise and educate U.S. companies about market opportunities and tradecraft skills. This session today is part of a 10-part series focused on export compliance, and this specific one will cover the Foreign Corrupt Practices Act. My name is Jacqueline Roeder. Many of you have seen me already. I'm an international trade specialist with the U.S. Commercial Service based out of San Diego. I'll be moderating the webinar today. Thank you so much for joining us. We have a great presentation lined up for you. As we've started every session, I just wanted to outline the entire series, what we've seen so far. Many of you are familiar with them and have attended all of them. Like I said, it's the 9th session, and then next week we are rounding out the program with Ask a Compliance Professional. This is going to feature 3 compliance subject matter experts, and they will try to answer any of the questions we did not get to during these 9 sessions or any you may have thought of after this webinar concludes. Please send us those questions in advance so you can direct them to myself or to Anthony Sargis, who you've been receiving correspondence from. Bob will be one of the 3 specialists that will be joining us, so he's happy to address those that he can during that session as well. Our presenter today is Robert Bowen. He's an international trade attorney holding both a JD and an LLM with a focus on export control laws, economic and trade sanctions laws, and customs laws in the U.S., along with several other countries. He has extensive experience leading global trade compliance teams at publicly traded technology and aerospace companies. He's currently serving as Export and Trade Compliance Counsel for ServiceNow, a software company that develops a cloud computing platform to help companies manage digital workflows for enterprise operations. He's also incredibly active with the DEC here in San Diego, and I should mention that the San Diego DEC, the Connecticut DEC, and New Jersey DECs are all very involved in the production of this series. That being said, Bob is leading this discussion in his personal capacity and not on behalf of any other entity or organization, including ServiceNow, and thus there should be no attribution of his remarks to any other entity or organization. The purpose of the presentation today is purely educational, and Bob is not providing legal advice or counsel. Lastly, before the event begins, I just would like to outline a few brief housekeeping items. You will be muted throughout today's event in listen-only mode, but if you have any questions as we go along, please feel free to put them in the Q&A box in the bottom right-hand corner of your screen, and be sure to direct your question to all panelists so we can be sure that we all are able to view it. We will wrap up this webinar with a Q&A, and we'll do our best to get to as many of your questions as possible. Finally, this event is being recorded and has already begun. So if any of you have any questions or have any issues with participating in a recorded webinar, please feel free to drop off now. For this week's session, the presentations and recordings will go out tomorrow morning by 9 a.m. EST, and that includes today's and yesterday's presentations. And it is now my pleasure to hand it over to our presenter, Bob Bowen. Thank you, Bob.
Okay, thank you very much, Jacqueline. Good morning, good afternoon. I hope everyone is well. Thank you for taking your time out on what I know is just a busy time and busy life for everyone and for all of us. I do appreciate the opportunity to spend some time sort of plowing into and through some of the basic ideas and principles behind the U.S. Foreign Corrupt Practices Act. As I'll do just at the outset, just to sort of reiterate what Jacqueline just said, and that is for these kinds of questions, these kinds of issues, I'm certainly not providing legal advice to anybody, but my hope is that you will see some things and hear some things and see some of the publicly available resources, and then take whatever questions that you may have of a very, very technical legal nature involving your business and your organizations to your respective counsel. I think that's probably the way to go. So with that, and before we dive into this presentation, let me just say I certainly do not intend on just reiterating and regurgitating every chapter, line, verse, and page here is a conversation starter. I'm happy to field as many questions as I'm able to answer. I will definitely intentionally pause about halfway through and pipe down and leave the floor to anyone who might want to ask any questions through the various means that Jacqueline has already summarized and indicated. So with that said, Jacqueline, let's get into the first slide. Okay, always good, I think, to start off, thinking about this just as by way of a pyramid approach, right? Start with the bigger picture and then sort of like narrow it down into the details, whether that's an upside down pyramid or now whatever visual works for you. I think the big idea here is that the United States is still to this day in a minority of countries, in the sense that the United States has a federal law which prohibits the engagement of people subject to that law, and we're going to talk about who is and who is not subject to this law, in their business conduct outside of the United States, and in particular business conduct outside of the United States that involves potential corrupt or bribery activities. Now, I say that the United States is in a minority of jurisdictions, and indeed it is. It's not alone. There are many other OECD countries who, in fact, as part of OECD membership, have also at least committed to placing in their domestic laws some similar prohibitions in what their persons and their nationals can and can't do when engaging in business outside of those boundaries. But as we'll see, the extraterritorial application really is the hallmark of the FCPA. I'll refer to it now as the FCPA. And in addition to this applying to prohibit corruption and bribery outside the United States, this should not be confused with our domestic bribery and corruption laws at the state and the federal, and indeed even at the local level. Final bullet point here on this slide is the idea that enforcement cases overall the last 20 years or so have been trending up. This is an area that didn't get a lot of prosecutorial and law enforcement attention for quite some time. It just so happens that after the terrorist attacks in September of 2001, 9/11, that's really when, for various reasons, the United States government got really focused on the FCPA as a tool and as a device that they thought was appropriate to use. And indeed, the data suggests that there's been an aggregate upward trajectory in law enforcement cases brought under the FCPA ever since, with, again, some little ups and downs here along the way. Okay, next slide, please. Right, so I did want to provide at least one slide here just on some of the core basic concepts that are actually found in the law. This is all entirely public information, and anyone who chooses to sit down to actually read the actual text of the FCPA will be able to discover this on his or her own if you haven't already. But be that as it may, I thought it would make sense to at least summarize the core content of the FCPA for our immediate purposes. As I said, the FCPA is a federal law passed in 1977, soon after Watergate, and some of the revelations that flowed out of the Watergate investigation about what various U.S. companies may have been doing overseas. Remember back then, because there was no FCPA, at least on the books of U.S. Legal books, there were certain practices and activities that back then could very well have been entirely legal, that nevertheless sort of led Congress to pass and the president to sign what we today regard as the FCPA. I will say that the initial statute was passed in 1977. It's been amended twice since then, once in 98, I believe, and sorry, 88, and then again in 98. But that's actually not significant in terms of the number of amendments, and indeed, particularly because the level of law enforcement activity has been so robust just in the last 20 years. All right. What I'd like to do is to spend a couple of moments just unpacking the two key requirements in the FCPA. If we don't digest anything else today, let's make sure that we get this right. There are different provisions within the FCPA that are, on the face of it, not apparently related, but actually when you scratch the surface a little bit, it makes sense that these two sets of provisions are actually housed within the same statute. Let's talk first about the actual anti-bribery provisions. As I said, I won't read this, word by word, line for line, but the basic idea is that it is prohibited by the FCPA for anyone subject to this law to pay or offer to pay or offer to promise something of value to a foreign official. And there's more to it than that, but that's the basic punchline. And furthermore, to corruptly influence a discretionary decision to be made by that official. Now, that's a mouthful. There's a lot there. But again, the basic idea here is that it is unlawful to offer anything of value to corruptly influence the discretionary decision of an official outside the United States. That really is the core key aspect behind what's referred to as the anti-bribery provisions. The assumption here is that those things of value would be actually paid, promised, or offered in order to obtain or retain a business benefit or a business opportunity or anything else that is a thing of value. And by the way, a thing of value, and there's a lot of cases that support this idea, a thing of value can even be down to, promising an employment opportunity of an immediate family member of an official. I'm really not speculating here. There are actually real life cases where there were pledges of employment opportunities to the sons or the daughters, if you will, of officials overseas to make a certain business decision that would be favorable to the offeror of that opportunity. I kind of stress this just to simply point out that the items of value that can get caught up in these anti-bribery provisions can be things other than, if you will, just cold hard cash. Okay, the second core pillar, if you will, of the FCPA is actually more of an accounting mechanism. So for those of you who might be in accounting departments or have some background in accounting or otherwise are involved in keeping the books of your organizations, this one will speak directly to you because these provisions of the FCPA require that the regulated person, and here I'm using person in the sense of a legal entity, make and keep books, records, and accounts which in reasonable detail accurately and fairly reflect transactions and the disposition of assets. Again, that's a mouthful, language that only a writer of statutes would love. I take that to mean that the FCPA requires an accounting system which is designed and actually does detect and prevent violations of the FCPA from an accounting perspective. So think of it this way. The anti-bribery provisions are more of a behavioral prohibition. The books and records provisions are more of an accounting mandate. So one is a prohibition on behavior. The other is an obligation of a certain level of bookkeeping and accounting. Now, I will tell you that in my experience, these two things are actually tightly related. And indeed, it would it's not impossible, but at the end of the day, if there are inappropriate business activities underway that would otherwise violate the FCPA, at some point along the way, that type of behavior should come to the attention of an organization's accounting department or finance department more broadly. And I think that that's the animating idea and principle here that was in the minds of Congress back in the 70s and still in the mind of the Department of Justice and the Security and Exchange Commission today. And by the way, too, going back to the first slide, I should have mentioned this explicitly, but I think you saw it. This law, the FCPA, is enforced by two government agencies, the Department of Justice, which enforces this law in civil cases, but also in criminal prosecutions, as well as the Security and Exchange Commission, which enforces this law in civil matters. Okay, let's then spend a little bit more time, and I'm going to get into some of the details here on this slide in particular, because again, this is sets out such a crucial foundation. I try to provide in 4 consumable bullet points here on this particular slide an idea of to whom does the FCPA apply? Who does this law apply to? Is it anyone? No, it's not. Is it someone overseas who has no business relationship whatsoever to a US person or a US entity or the US stock market? No, it is not. But if we take a deeper look at those 4 bullet points that I do provide here, I think that you will start to get a sense for the breadth of the scope of application, if you will, of the FCPA. And I think very simply stated, the ones that I think are probably the most meaningful probably are bullet points 2 and 4. That is, any company organized under US laws, and by the way, US laws also means the laws of the states and the District of Columbia. So basically, any corporation or LLC or other legal entity organized under the laws of a state or any other jurisdiction within the United States fall within the scope of the FCPA, as do, in bullet point number 4, any US citizens or residents of the United States wherever located, whether in the United States or overseas. In my experience, I think if you look at the history of how the FCPA has been enforced, those are usually the 2 jurisdictional grounds that the DOJ and the SEC rest on the most. The SEC obviously is deeply concerned about the first, because the very registration of stock on a US stock exchange is obviously what they would look for in terms of jurisdiction. But these are the 2 that I would guide your attention to. And in short, I think that there should be an assumption that you and your organizations are absolutely subject to the FCPA unless you, consulting with your counsel, somehow get comfortable with a different answer. Okay, let's go ahead then and go to the next slide, please. Okay. Again, a little bit of a definition. And by the way, the FCPA, for those of you who maybe have read it or are otherwise familiar with it, all said and done is actually a very short statute. It's not one of these big sort of, tomes that Congress passes and and then no one reads because it's too long. It's sort of a barrier to entry. The FCPA is actually a fairly short statute, but it has some crucial definitions. And I have set out on this page the definition of a foreign official as found in the FCPA. And again, I think what you will see is that effectively what this means is for those of you who are looking to expand your businesses overseas, maybe for the first time, maybe getting into some new overseas markets, any interactions that you or your companies may have with government officials at any level outside the United States, I would strongly encourage you to cross-reference those encounters with this definition. I think it would be extremely unusual if a US company operating overseas, interacting with officials in that country overseas, was not interacting with individuals who satisfied this definition. So just as I said at the end of the last slide, I think that the assumption should be that one is subject to the FCPA equally. I think that the safe assumption starting off is that any interactions with officials outside the United States trigger this definition within the FCPA. The next definition that I provide here, again, for those of you who are in the accounting world, reasonable detail. This is basically a definition that says that reasonable detail means a level of detail that would satisfy prudent officials in the conduct of their own affairs. This has been tested a couple of times in some of the cases that have actually been brought, but I'm not a technical accounting expert whatsoever, but I don't think I have seen any position that the government has taken that I think would be shocking to the conscience of a technical professional accountant. You can probably find some dealings here or there involving the SEC or the DOJ that might, but I think the basic idea here is that there cannot be woefully deficient accounting controls that are somehow spruced up to be accounting controls that would satisfy the books and records provision of the FCPA. I think we should spend some time on the next subject because this one is, I think, a minefield for the unwary. And I hesitated to even put this up for discussion in today's conversation, but I thought just in the interest of full transparency disclosure, I had to. The next bullet point on this slide discusses what are sometimes euphemistically referred to as grease payments. They actually have the rather odd, in some ways, distinction of actually being specifically called out in the statute as being a potential exception to the FCPA. This, as I said, is a trap for the unwary. I will say that this is an area where I think that cautious companies, in my experience, do not eagerly take advantage of. But then again, by the same token, it actually is really in the FCPA that there is a carve out for payments that would facilitate or expedite routine governmental actions, such as decisions on straightforward, standard, regular applications for permits or licenses or other kinds of official documents, so long as the official in question is not being incentivized to do something outside of his or her day-to-day obligations, and that would cause him or her to run afoul of his or her official duties. Now, that's a mouthful, and as I think that you can automatically see, this is a delicate area. It is easily stretched and maybe even exploited. I would just urge significant caution for any organization that might have its eyes zero in on this exception, thinking that this is a way to sort of get out from underneath the entirety of the FCPA. That would not be my reading of this, but then again, it's their food for thought. Likewise, there is also an odd provision in some way within the statute that allows for an affirmative defense. And that is to say, a defense that might be available to a company who is the subject of law enforcement action, allowing for that company to make a showing that whatever payments that were made or offered or promised were in fact entirely lawful under the written laws of that overseas country. Again, this is a bit riskier. I've seen this work. It is actually in the FCPA. I think that again, this is definitely a riskier practice. I think that efforts are better directed and resources are better directed towards steering as far away from even these questions as possible. But again, the FCPA does provide us with this affirmative defense. Final point here for those of you who have been involved in any law enforcement matters involving the DOJ, not just the FCPA, but in many ways, the FCPA is front and center of this. The Department of Justice, for the last couple of years, I would say, has been bending over backwards to stress that they are looking for individuals. It is not enough, I think, of the DOJ's mind in today's day and age for there to be a law enforcement action brought against a legal entity and only the legal entity, without also a scrutiny and a review by DOJ officials about individual actors within that organization. And those of you who are familiar with some recent DOJ guidance on this question of individual accountability will understand what I'm talking about. This is an area that I think has always been clear in the FCPA context, but I just simply am giving a shout out to the fact that the DOJ is being exceptionally clear about how they don't regard themselves as being in the business of prosecuting or civilly bringing litigation against legal entities alone. Quite the contrary, actually. Okay, next slide, please. Okay, maybe what I will do at this point, this may be a good point along the way to pause, at least to see if there are any initial questions on the first couple of slides, because it's been a heavy lift. That was the technical legal content, if you will. The rest is talking about now what.
Thanks, Bob. We did have a few questions come in. One of them you already answered, and one asked for you to define foreign official before we got to that slide. Another question was, does the FCPA also apply to U.S. individuals who seek employment by foreign entities in exchange of something of value?
Well, so if that something of value is offered up to corruptly influence any employment decisions, whether involving the offeror or the payor or someone else, the answer is yes. Again, I would encourage that question be directed to the person's legal counsel, but I think the way I read DOJ guidance on that question, again, I think a critical question would be whether or not there was an improper motive or an improper effect related to that payment or promise or offer of payment.
Perfect. Thank you, Bob. And then the other question I believe you're about to cover is, when hosting a foreign official, what are some ways to reduce the risk that an act is viewed as having a corrupt purpose?
Sure. Yeah, happy to address that in the next couple of minutes. It's a great question, and it really is a great question. We are definitely going to talk about that.
Perfect.
So hold tight on that one. Let's spend some time at this point then on sort of some general thoughts and considerations and criteria about, in an organization setting, after we understand the prohibitions and the obligations found in the FCPA, once we have concluded that in fact it does apply to our overseas business practices, to our employees, to our directors, to the members of our board, now what? Right? And this is where all of the statutory language in the world doesn't mean a whole lot unless and until it is effectively applied within the four corners of that organization or legal entity. I offer up on this slide, and again, I apologize because there's a lot of ink and there's a lot of busyness and there's some wordiness going on here, but I'm hoping that this slide might serve as a reference tool or a resource, if you will, just like some of the links that I think we're going to provide on the last slide here for your future reference. But certainly, I think the DOJ and the SEC have been very clear that they regard a fulsome risk assessment as being a mandatory must-do item. I think that it is clear that you and your organizations want to look in the mirror. You want to do a full investigation, probably supported by your legal counsel, of what your FCPA risks really are, in transparency and in candor and in taking the facts where they take you, so to speak. What really, no fooling, are your FCPA risks? What I offer here are some sub bullet points on some questions that you might ask yourself. Right? What countries are you operating in? That's actually one that is a real deal. And there is an organization called Transparency International. We provide a link to it on the last page. There is what's called the CPI, the Corruption Perceptions Index. Some of you may be familiar with the CPI, but be that as it may, I don't think anyone will be surprised to learn or already know that the countries of the world fall all across the range from being regarded as being incredibly risky from a corruption standpoint, all the way to those countries that are regarded as being of relatively low corruption risk. So I would certainly encourage that study be given to the specific countries that you may have in mind with reference to that CPI. That's crucial. I think that that's a really, really crucial factor, because you may find yourselves coming to some different conclusions about the internal controls that are necessary, whether or not you're looking at expanding into country A or country B, because A and B could present to your companies vastly different risks level themselves, regardless of the nature of your particular business. I'll just simply highlight a couple of other bullet points here. The third one down, and actually the second one down too, but in particular the third one down, cannot stress enough some of the FCPA risks that are presented by third parties, or if you will, middlemen, or if you will, agents. I would take a highlighter, take your bold, red ink pen and underline this one and highlight this one 3 times over, because you don't need to take my word for it. These dispositions and settlements are entirely public documents, but a significant percentage of legal enforcement cases brought by the DOJ and or the SEC against a person subject to the FCPA involve at some level a third party, whether it's a channel partner or a prime contractor or a reseller or a distributor or a lobbyist or a freight forwarder or a customs broker. Customs brokers are one of the all-time all-time favorites, if you will, and I use that term favorites loosely. Any of you who are distributing hardware into overseas customs territories using customs brokers in those countries, this one's for you. We all love and use and rely upon our customs brokers. Therein is why this is risky. It's that very reliance. So I would absolutely draw your attention to ensuring that you have done your full due diligence and you understand who the third parties are that might be coming between you and foreign officials as defined by the FCPA. It's absolutely crucial, absolutely crucial. You'll also see here that I give a shout out to discounts and rebates. Again, for those of you who have go-to-market strategies or sales strategies that involve something other than direct sales. One of the all-time favorite, and again, I use that term a little bit loosely, but one of the all-time favorite mechanisms by which there could potentially be some FCPA risks are the concept of discounts and rebates when there is a government official involved somewhere within the chain of the originator, a third party, a channel partner, and then the ultimate end user or end customer who might actually be a government official. We probably don't have time to get into this, but this is again where the accounting department needs to come in, because the DOJ has been quite clear that they have certain expectations about the passing through of discounts from the originator all the way through to the end customer. And the reason why this is risky is the following. Suppose you have a manufacturer that operates through channel partners overseas, and then those channel partners sell and resell, if you will, the manufacturer's products ultimately to a government agency in an overseas country. If the original manufacturer, the originator, were to offer a discount to that channel partner, and if that discount is not passed through all the way to the ultimate end user, that potentially risks that channel partner amassing a pool of funds, right? It's getting a discount from the manufacturer, but is not passing that discount on to, if you will, its customers. The risk here is that that means that that channel partner, if it is not a bona fide, legitimate, good faith actor, potentially could be in a position to start amassing a fund. And what it may choose to do with that fund in turn brings about potential FCPA risks. This is a real thing, and law enforcement is onto this. And so again, I would just encourage that this is an area for your assessment and consideration. And again, the rest of this I think is fairly self-explanatory. I think marketing funds, for those of you who use it, are definitely something to interrogate. I think that any company who is operating in an overseas market that is heavily regulated, that might require permits or licenses or import approvals or distribution licenses, any area of goods or services that are heavily regulated by those overseas markets. I'm not saying don't do it, you shouldn't do it. That's a judgment call between you and your lawyer, but I'm just simply giving it a shout out that that's an area of potential FCPA risks that should be part of your risk assessment. Okay, All of this is to say that that risk assessment needs to do something. The risk assessment needs to make a difference. The risk assessment needs to change your business, and that is where the concept of internal controls comes into place. I am sure that those of you who are representing organizations today have already some level of internal controls, be they financial or intellectual property or other proprietary business information controls. I would double down though on those existing controls once you have performed your FCPA assessment, because it's very likely that you may find yourself needing to fine tune some of those controls. The one thing that I will say here on this particular subject is the critical importance of the segregation of responsibilities. This is something that, again, is fairly straightforward, but I think nevertheless is so important that it bears a little bit of underscoring here. And that is, I think that whether in the FCPA context or in other legal and regulatory compliance scenarios, I think it's elevating one's risk to have something less than full segregation of responsibilities, and that is no one person should be able to make decisions, allocate funds, commit funds, and otherwise operate, if you will, as a lone wolf without other disinterested functions in the organization having to approve what this individual proposes to do. I think that that's one of the hallmarks of this idea behind segregation of responsibilities. I think it's crucial. I think it's critical. I think there are SOX issues involved. And again, this is something that I suspect any and every accounting department would also fulsomely believe in. The DOJ has also been very clear, very clear that these internal controls and these compliance programs actually have to work. They actually have to make a difference. They actually have to prevent and detect something that might be potentially nefarious and maybe even in violation of the FCPA. Final shout out here, training. It might even go without saying, but let's say it anyway. Training is absolutely crucial. I think that a compliance department or a legal department has to equip its colleagues in other functions with the tools and the awareness so that when they are out, if you will, in the field, interacting with government officials, maybe interacting with resellers, interacting with partners, they make the right decisions. And I will just simply point out that in my experience, the sales folks, the marketing folks, and the business development folks probably are the functions that are in greatest need of this training, not because they don't want to do the right thing, but those three functions, in my experience, are the ones who are just in the most vulnerable positions, if you will, to come into contact with an official in an overseas market who doesn't necessarily want to do the right thing. And so I would train every function, but in particular, those three, I think, really are going to need further and extra guidance. Let me again stop here at this point and see if there are any other questions.
Hi, Bob. We did get a few more questions. You had covered this question came in before you covered it. It was, to what extent is a U.S. company liable for the actions of a third-party representative overseas? I would say you covered that quite thoroughly. This question came in, you mentioned a prime contractor when discussing a channel partner. Can you speak more to the risks of running afoul of the FCPA as a subcontractor to a prime contractor working for a federal or a foreign government?
Yeah, sure. I mean, that's actually that's a very good question. And again, I would encourage the requester to take it to his or her counsel. But I can just say, just as a general matter, if I were a subcontractor working with a prime in a public sector business opportunity, I would want to stay very close to the accounting practices and the financial practices and the segregation of responsibility disposition of the prime. How did the prime win the business in the first place? As I think I mentioned either on this slide or the next slide, for example, was there an auction? Was there public bidding? How transparent was the bidding process? How transparent was the auction process? Again, this is a matter of public record, but a lot of companies have gotten themselves in trouble for potentially participated in bid rigging and conspiracy to frustrate legitimate auctions because of some unlawful collaboration with someone else, in many instances, not all, the prime. And so if I were working for a sub, I would want to absolutely insist upon maximum financial transparency, obviously between the sub and the prime. I sort of take that as a given, but also between the prime and I think the hypothetical that this question has in mind, the ultimate customer, if you will, which presumably is a public government agency outside the United States. So I would absolutely, be it by contract or escrows. There are lots of tools in the tool chest here to ensure that you as the sub absolutely maximize that level of transparency, because you do not want to get yourself involved in an investigation that focuses on what you knew and what you should have known. If there are questions that come up later on, you want to fully vet and interrogate that moving forward before you ever get yourself in that situation in the first place.
Perfect. Thank you, Bob. Those are the questions that came in. And please feel free to continue putting your questions in the Q&A.
Sure. Okay. Well, on this slide here, some of the things I maybe have gotten ahead of ourselves a little bit here, but again, next steps and monitoring, and I will mention a couple of things here that have come up during the course of our conversation that I don't actually think are in the slides, but I think it would be helpful. I've already mentioned how the U.S. government agencies are quite clear that they are not impressed by wonderful programs and policies and institutions that just sort of sit there and gather dust. Don't do that. Not a good idea. They have to be constantly assessed for effectiveness. As I indicate, you don't need to take my word for this. Those government agencies have provided guidance documents. I think at the end of this presentation, we link to some of those. Again, calling out the importance of working very closely with folks who are in your accounting department. I know I've said that a couple of times. By the way, I should also point out that there are some cases where there have been law enforcement actions with respect to the anti-bribery provisions of the FCPA, but not the books and records provisions, and vice versa. So it does not mean that because either the SEC or the DOJ decide to bring an action with respect to one set of provisions, that it's either mandated or prohibited from bringing a law enforcement action with respect to the other set of the provisions. Now, it probably is unusual for there to be an instance of corrupt practices without there also being a books and records problem. But in concept, there need not be, and certainly the DOJ and the SEC do not have their hands tied just because they decide to bring an action with respect to one set of provisions but not the other. They are free to do so, and they have done so. But again, I will offer up their public documents and settlement agreements for your review and study on that question. I've already given a shout out here to some of the specific risks. I've already talked about some of the dangers, or at least the risks presented by agents, by middlemen, by discounts, by regulatory approvals, the lone wolves. Let me also give a shout out here, and I think on the next slide we'll see an enforcement action just recently that involved acquisitions. For those of you who work for companies that are acquisitive or in the process of acquiring a company or have recently acquired a company, I will just simply state what government agencies I think again are very public about, and that is, by and large, when there is an acquisition, particularly a stock-based acquisition of a company, the buyer of that business takes on legacy legal challenges, including potentially FCPA issues and problems and questions that may or may not have transpired years before the buyer of that business, in fact, bought that business. Some of you may have been involved in this. Some of you may be very well aware of this. But again, I would just give a shout out to those of you who are potentially looking at acquiring a business that, as part of the due diligence, I would want to make sure that your legal departments are absolutely on, and I'm sure that they will be, but are absolutely including FCPA due diligence of the acquisition target well in advance of the actual close of that target. I mentioned here contractual terms and conditions. I think that's fairly straightforward. I would be a little bit artful and clever, though, in how those agreements state the mutually applicable legal commitments and compliance with laws commitments, simply because if you're doing business with a distributor or a reseller or a customer overseas, you might want to ask yourself whether that entity itself and as a standalone partner or customer is or is not already subject to the FCPA. One thing that I've seen some companies do here is just to use slightly broader language that the parties agree to comply with applicable applicable anti-bribery laws. You just knowing that for you, that includes the FCPA. It may or may not also include the company overseas that you're doing business with. But again, there are ways contractually to address that. Audit rights, I think one needs to be reserved in audit rights. And in fact, if you do contractually reserve those audit rights, I recommend that you be able and willing to actually take advantage of that. Final bullet point here on this slide. This is something that the Department of Justice in particular has been very, very vocal about, literally just within the last 12 months. And that is the risks that they regard are presented by messaging apps and ephemeral messaging apps in particular about a company's record keeping and investigative cooperation posture. This includes the FCPA. I should say, though, it's not just limited to the FCPA context, but for those of you who have not yet explored this, the DOJ in its guidance documents, but also some individual speeches that very high-ranking DOJ officials have been giving literally just within the last 6 to 12 months. This is clearly an emphasis right now and a focal point of the DOJ. And so I would just simply just highlight this for your consumption. Let me address something that I think one of the questions that has already been asked raises, and that is whether or not, in light of all of this, does this mean that there can never be any, travel and entertainment, if you will, things of value conferred to an individual who meets the definition of foreign official? The answer is no. The answer is no. This does not mean, And just to be clear, the FCPA does not say that there can never be things of value provided to a foreign official. That is, I think, not the legislative intent. I don't think that that has been the law enforcement intent of either the DOJ or the SEC. And indeed, I think the FCPA itself provides for some guidance on when, where, and how there actually can be the provision of things of value to government officials. One of the best examples of that is, suppose a U.S. company wants to invite government officials from another country to visit its facilities here in the United States, maybe to do some product demonstrations here in the United States, maybe to walk these foreign officials through a manufacturing site, something along those lines. There are ways to do this, and there are ways to do this that I think are safe from an FCPA perspective. But again, I'll encourage you to take this to your legal counselors. It seems to me that there has to be a rigid discipline to the subject of proportionality and reasonableness. What do I mean by that? What I mean is that I think it would be by and large appropriate to provide to these visiting officials coffee mugs or baseball caps or the like, maybe even to provide nominal refreshments, for example, during the course of the visit. I think that stands in great contrast to paying for these officials to stay at a 5-star hotel, paying them to go see, from front row seats, an NBA game. And I think that there are lines in the sand, if you will, and shades of gray between one extreme or the other. I would just simply put out there that the idea that there may be government officials invited to some event is something that I think needs broader review. And again, I think the sense of proportionality and reasonableness is absolutely got to be critical to that assessment. My only point here in stressing that is that it's not a hard and absolute no, this just cannot be done. And in fact, I think many of you probably already knew that, because I suspect probably a lot of you have already had experience of demoing products or maybe even hosting reasonable and appropriate visits by foreign government officials. By and large, in concept, there's nothing outright prohibited in that by the FCPA. Okay, next slide, please. Okay, it seems like everyone always sort of wants to hear about companies of late that got this wrong, and I think that there are some lessons to be learned here in these 3 cases that I summarized here. Again, these are all public information. It just so happens that all of these cases were settled, and those settlements were publicly announced last December. Some of you may be familiar with these cases, aware of these cases, but let's do this just in the time that we have here, and I see we're at the top of the hour. I think that there are some lessons to be learned sort of in vivid ways through these 3 cases. I think the ABB case is interesting because it demonstrates what it looks like when a company is facing bribery and corruption investigations from multiple jurisdictions at the same time. In this particular case, ABB, a Swiss company with businesses all around the world, including the United States, found itself getting into some crosshairs with respect to some of its business practices in South Africa. So right off the bat, this conjures up this idea that business practices by one company in several jurisdictions could trigger reviews and investigations by enforcement officials in those multiple jurisdictions. And in fact, that's what happened here with ABB. I think one of the key things here, at least from an operational standpoint, to highlight is that this particular case involved the hiring of subcontractors at a state-owned company. And notice this was not an outright agency and office of the South African government. This was a nominally private, but then again, not really fully private company, in order for ABB to win engineering contracts at I think these were power generation sites and facilities. The allegation was, and indeed ABB, I think acknowledged that some of the payments that it was making to these subcontractors in South Africa, in fact, went to the benefit of officials in South Africa in decision-making positions. Now, what's I think interesting about this is if you look at some of the numbers here that I provided here, the DOJ, there was a criminal penalty of $315 million. That means that indeed the DOJ brought criminal prosecutions against ABB, and in fact it did. But the SEC also chimed in with a civil penalty of its own for $75 million. And on top of this, South African and Swiss officials also brought legal actions in their own right and under their own laws against ABB. By the way, I should add, I think I read, and again, publicly available information. My understanding is that this was ABB's third FCPA law enforcement matter, I think within the last 20 years or so. And so that just goes to show that some companies, I think, take a little bit longer than others to sort of bring themselves on the right side of these obligations. The second case is the Honeywell International case. This involved Petrobras, which some of you may be familiar with and will know, a state oil company in Brazil. Unfortunately, Petrobras has some experience, not only with FCPA officials in the United States, but indeed officials in multiple countries, including its own country, Brazil. I think what's interesting about this one is that part of the settlement of Honeywell, and by the way, this had to do with the behaviors of a Honeywell International subsidiary in Brazil, if I understand that correctly, is the forfeiture. Right? Notice that part of the settlement was a forfeiture of ill-begotten proceeds, if you will, that came in to this Honeywell subsidiary by practices that the DOJ found to be in violation of the FCPA. I think the key thing here is just to understand that forfeiture procedures are available to the U.S. government in the context of legal enforcement actions involving the FCPA. That's one of the remedies that the DOJ has available to it. The third one here that I'll call out, again, recent case involving Safran. Some of you may be familiar with them. This one involves a consultant in China who was apparently a close family member of an official in an agency within the Chinese government, and that official was in a position to make contract award decisions that I think involved the construction and design of laboratories in the train systems in China. And indeed, these were subsidiaries in US and Germany, but there's a crucial twist to this one that I highlight here. The alleged wrongdoings by these subsidiaries in the US and Germany occurred prior to Safran acquiring those subsidiaries. Remember what I said a couple of minutes ago about acquisitions. This is a good example of how a company that acquires other businesses needs to really seriously scrutinize and interrogate those acquisition targets using FCPA lenses, if you will. Safran actually, as I understand these cases, acquired these companies, then apparently, came to have some level of understanding of these behaviors that predated the acquisitions. And then I believe that they actually ended up voluntarily disclosing these matters to the US government. And again, the rest, so to speak, is history. But again, this was all public as of last December. You'll also see here in this particular case that the DOJ included in its settlement of these matters profit disgorgement, right? Again, similar idea, same general idea, that is to say, ill-gotten gains are something that the U.S. Department of Justice can and will claw back. Incidentally, I will note, final note on the Safran case, the DOJ specifically declined to actually prosecute in a criminal sense Safran for these. This was all handled by the DOJ as a civil enforcement action, not a criminal prosecution. Okay, next slide, please. Okay, here's just a page of resources. My hope and intent is that these links will take you to resources that I think will be helpful and valuable and potentially useful guides moving forward. I will just give one quick shout out to the second to the bottom point for the U.S. Commercial Service. Obviously, this is within the Department of Commerce, Jacqueline's agency, Anthony's agency. I will say that for those of you who are potentially visiting overseas markets and thinking about what it would look like to expand in those overseas markets, I would not bypass the information and the resources available by commercial service personnel stationed usually at U.S. embassies and consulates in those overseas countries. I think that those individuals can be great sources of helpful information to provide sort of a boots on the ground perspective about where they see potential FCPA risks to U.S. companies attempting to operate in those markets. And with that, I will, Jacqueline, I guess, renew the request for any questions that may be outstanding.
Perfect. Thank you so much, Bob. That was wonderful. You do have incredible foresight. As someone asked, does the FCPA really prevent me from providing gifts to my foreign colleagues? You did touch on that and the important distinction between some of the things that could be considered a gift. One question came in: what if the violation of the FCPA is due to negligence rather than intentional? And you kind of touched on that throughout the presentation, but I don't know if you want to speak to that.
Yeah, I mean, that's a question that probably should go to the requester's legal counsel. I mean, I will say though, by and large, I think the FCPA on its face discusses this, and the DOJ certainly does. There has to be some level of knowledge. There has to be some way that the DOJ and the SEC, but particularly the DOJ, has to believe that the company knew, whether through negligence or otherwise. I think the key thing, and again, this is out there on the FCPA and the DOJ's own website, there has to be an element of knowledge, I think.
Perfect. Thank you, Bob. All of the other questions that have come in were asked prior to you answering them through your presentation, which was very thorough. So I'll give people one last opportunity to write into the Q&A box, but as mentioned prior, Bob will also be on the Ask a Compliance webinar next week as well. So if you have any questions that come up between now and then, please direct them to myself or to Anthony Sargis, who's been sending you emails. And if no others are entering the chat, then I will conclude this webinar on the Foreign Corrupt Practices Act. Thank you to our presenter, Bob Bowen, for the incredibly informative presentation, and thank you to all of you for joining us today. Should you have any questions, please don't hesitate to reach out to us at the Commercial Service. We're here to help you expand your business internationally. We hope you have a great afternoon and hope to hear from you. Thank you so much. Thank you, Rob.
Bye now.